Many people worry about hacking, cyber threats, and those things do happen, but most trade secret misappropriation occurs at the hands of an employee or a former employee.
And in a number of the audits that we've performed from time to time, clients have big gaps in their processes. Like they don't do an exit interview for a salesperson, they don't collect their computer for 3 weeks. Or they're not on top of evaluating what type of access that employee has to the computer system and immediately shutting it down. While in theory, the client says, yes, an employee departs, we have to cut off access. But maybe they don't have a protocol in place to make sure that the IT people are informed when an employee resigns. And so these types of gaps in process or in practice, even though they might have a good policy in place, is something that we've been able to highlight for clients and help them develop a better strategy and best practices to protect those trade secrets.
Sophisticated clients should also be tracking and monitoring use of such data, such information, so that when a problem does arise, it's quite easy to figure out how it arose, and that will be useful evidence in prosecuting these cases. If you can show when certain documents may have been accessed, by whom, and so forth.
Clients are most concerned that in litigation, the question is whether their trade secret will be actually still kept confidential, which was a big concern under German procedural laws, for example, before we had the new laws. But nowadays, these problems can be addressed. There are options to have a court proceeding and still make sure that the secret is not leaking outside the group of people that actually should be dealing with it.
What's hardest is, in my opinion, is not overstepping your bounds, right? When you're in trade secret litigation, it's very important to define what the trade secret is and not to do that too broadly so that you're implicating information that may be public and that won't be as easy to sell to a court as something that's private and valuable to the company. In the same regard, when you're enforcing non-compete agreements, of course you have to abide by the law of the jurisdiction, but people have a right to work. And if you enforce non-compete agreements in an overbroad way, you're going to get a lot of resistance from the decision makers in those cases.
Clients are sometimes concerned that it does take a lot of effort to put in a comprehensive trade secret program. The fact of the matter is, if you're going to have a program, you should do one that is comprehensive, because taking some steps but not others just leaves you with holes where you can still suffer from misappropriation as though you had almost no protection in the first place. And so it does require a comprehensive attention to the issue. It seems perhaps harder than it is, but it's important, because if you really do have important trade secrets that you don't want to get out, you should spend the time and effort to protect them.